On this vote, the yeas are 51, the nays are 49. The motion is to agree to. The Senate, sitting as the court of impeachment, stands adjourned sine die. Majority Leader is recognized.
For the information of members, there are no further votes today. Now, I remind all members that we have very serious business ahead of us in the next few days, and we'll keep you informed as to schedule as things can get scheduled.
Republican Leader is recognized. The Senate will be in order. Would senators please take their conversations to the cloakroom?
Madam President, we've set a very unfortunate precedent here. This means that the Senate can ignore, in effect, the House's impeachment. It doesn't make any difference whether our friends on the other side thought he should have been impeached or not. He was. And by doing what we just did, we have, in effect, ignored the directions of the House, which were to have a trial. We had no evidence, no procedure. This is a day that's not a proud day in the history of the Senate.
If you want to find her, that would be.
Madam President.
Senator from Utah is recognized.
Madam President, I ask unanimous consent to enter into a colloquy with my Republican colleagues.
Without objection, so ordered.
Madam President.
Senator from Utah would hold. We do not have order in the Senate. I would ask all senators to take their conversations to the cloakroom as well as the staff. The senator would just hold till we have order, please. Senator from Utah is recognized.
Thank you, Madam President. What we've witnessed today is truly historic. This has never occurred. Nothing like this has ever occurred. You know, under Article 1, Section 3, Clause 6, we've been given a duty. We've been given the sole exclusive power to try all impeachments. Try all impeachments. Not some of them, not just those with which we happen to agree, not just those that we are happy that the House of Representatives undertook to prosecute, but all. The word try is also significant. It refers to the word trial. It's the same word. It's a proceeding in which the law and the facts are presented to finders of fact in front of judges in order to reach an ultimate disposition. In a criminal proceeding, it would be an ultimate disposition culminating in a verdict of guilty or not guilty. We were precluded from doing that job today, and we were precluded from doing so in a way that is not only ahistoric and unprecedented, but also counter-constitutional. Nothing could be further from the plain structure, text, and history of the Constitution than that. So let's look at the arguments that we would have heard, that we could have heard, that we should have heard today, had things unfolded as they were supposed to. Had things unfolded in a manner consistent with the oath that we took, first when we were sworn in as United States Senators. We're all required to take the same oath to the Constitution when we did that, but also the oath that we took just a few hours ago in this very chamber, in this very case, to decide this case impartially. What would we have heard? Well, first and foremost, regardless of what you think about what a trial consists of or how different people might cleverly define the term, a trial will always, at a minimum, involve lawyers. And unless the person is proceeding pro se, you will always have lawyers there. Or at least one side will always be represented by lawyers, and in 99.9% of all cases, both sides will. You will hear from lawyers. We didn't hear that today. We didn't hear from the committee of individuals appointed by the House of Representatives to be the House impeachment managers or prosecutors. What else would you expect to hear? Well, you'd hear evidence. Evidence would be brought in. Sometimes trials in the Senate involve bringing in evidence in a documentary form. Other times you might have witnesses. We didn't have any witnesses. We didn't have any documentary evidence other than that which was charged. So let's talk about what was charged and what evidence we could have, would have, and should have heard had we done our job today. Well, the accusations in this impeachment trial can be fit into two categories. Category one is found in Article 1 of the Articles of Impeachment. Article 1 alleges that Secretary Mayorkas repeatedly, defiantly did the exact opposite of what federal law requires, namely that under myriad circumstances, 8 or 9 different statutory provisions that he violated, he was required to detain people whom he did not detain. But it's not just that he didn't do what the law required, he did the exact opposite of that. Instead of holding them until such time as they could be removed or alternatively adjudicated to have the status, whether under whether in the context of immigration parole or asylum or otherwise, he just released them. And in many cases, gave them work permits. We would have heard evidence about the fact that memoranda issued by Secretary Mayorkas within the Department of Homeland Security didn't just tolerate this result, they instructed this result. We would have heard evidence about the fact that at the outset of the Biden administration, Secretary Mayorkas, when asked what he would tell those traveling through the caravans, those paying many thousands of dollars per head, in some cases tens of thousands of dollars per head, to international drug cartels, instead of telling them don't do it, he said, maybe don't do it yet. Give us a few weeks before we're ready to receive you. Showing intention, a forethought, to facilitate the violation of federal law. We would have heard evidence about how he instructed his own department to violate those rules. We would have heard evidence about how directly contrary to federal law those things are and contrary to his own oath and his own duties. Now, as to Article 1, the Senate chose to dispose of this today by doing something it's never done in any context anywhere close to this, with a point of order that said as follows. The majority leader stood up, defiantly refusing to have the Senate perform its obligations, and raised the following point of order. He said, I raise a point of order that impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, is therefore unconstitutional. All right, let's talk about that for a minute. Now, had we been permitted to have a trial, alternatively, had we been permitted to go into executive session, alternatively, had we been permitted to go into closed session, as several of us moved today, we would have been able to hear arguments about this, about how wrong this is, because that's what you do when you have a trial. You hear evidence, you hear arguments from lawyers, and when someone makes a legal argument, as Majority Leader Schumer just did, you can consider their implications, and most importantly, consider whether or not the argument is right. Because when we're sworn in a trial of impeachment, our job is to serve as both finders of fact and adjudicators of law relevant to this case. We were denied that opportunity. So while we're exploring what we would have heard had we gone to trial, had we done our job, let's also explore what would have happened in a real trial had somebody made an actual motion and we've been permitted to do our job. Well, look, first and foremost, this is patently absurd to argue that a willful refusal to obey the law that one has a sworn solemn obligation to perform is somehow not impeachable.